Stop what you are doing right now. If you hold citizenship in 2 countries, if you carry 2 passports, if you filed a naturalization application while keeping your home country nationality, if you were born in the United States to foreign parents, Congress is actively debating legislation that could force you to make a choice you never expected to make. And I am not here to alarm you. I am here to give you the facts. Because right now, in March 2026, there are not 1, not 2, but 4 separate legal developments moving through the U.S. system simultaneously that every dual citizen, every green card holder with foreign ties, and every immigrant family in this country needs to understand. The details are dense. The legal language is confusing, and most of what you are reading online right now is incomplete or outright inaccurate. Stay with me for the next 8 minutes. I am going to break all of this down clearly, calmly, and factually because your legal future deserves nothing less. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel I break down complex immigration policy developments into clear, fact-based analysis that you can actually understand and act on. I do not deal in rumors. I do not speculate. When something moves in Congress, at USCIS, in the federal courts, or in the White House, I come to you with the source material, the legal context, and the practical implications. Before we go any further, I want to be transparent. I am not your attorney, and nothing in this video constitutes legal advice. This content is strictly for educational and informational purposes. For guidance specific to your case, please consult with a licensed immigration attorney. That said, understanding what is happening at the policy level is the first and most important step you can take right now. So let us get into it. There are 4 separate developments you need to know about. I am going to walk through each one, explain what it says, what it does, and, critically, what it does not yet do. The first, and the one generating the most online anxiety right now, is a proposal known informally as the Exclusive Citizenship Act of 2025. This bill, which is currently being discussed in Congress as of March 2026, would, if passed, require individuals holding dual U.S. citizenship to formally renounce their second nationality within 1 year of the law taking effect. Let me be precise about something important. This bill has not passed. According to independent legal analysts, its probability of passing in its current form is approximately 3%. 3%. But because the proposal exists, because it is being debated on the floor, the fear index among dual citizens is extremely high right now. And that fear, while understandable, should not drive rash legal decisions. But here's where this becomes critical, and what most people discussing this bill are completely missing. Even a bill with a 3% passage rate creates real-world consequences. It signals a political direction. It tells us where at least a faction of Congress wants to go, and it is already being used by some enforcement-adjacent voices to pressure dual citizens into voluntary renunciation they do not legally need to make. So you need to know this exists, and you need to know what it actually requires versus what people are claiming it requires. The second development is H.R. 2356, the Dual Loyalty Disclosure Act. This is a narrower, more targeted bill, and in some ways, more immediately consequential for a specific group of people. H.R. 2356 focuses on individuals who hold or seek federal employment, security clearances, or who participate in federal elections. Under this proposal, those individuals would be required to publicly disclose any foreign citizenship they hold. This is not a ban. It is a disclosure requirement. But the implications for anyone working in government, intelligence, the military, or federal contracting are serious and real. If you fall into that category, this is the bill you should be watching most closely. The third development sits slightly outside the dual citizenship conversation, but feeds directly into it philosophically and legally. Executive Order 14160, issued by President Trump, is currently under Supreme Court review. The order touches on birthright citizenship, but more broadly, it is establishing what legal scholars are calling an exclusive allegiance doctrine, the concept that U.S. law should increasingly favor singular national loyalty. This executive order has not been upheld. It is being challenged. But if the Supreme Court affirms even a portion of its legal reasoning, it creates a constitutional framework that future dual citizenship legislation could build upon. Consider it a warning signal, not an immediate threat, but a structural shift in the legal landscape worth monitoring. And the fourth development is the most operationally immediate, and it affects a specific but significant group of viewers. If you are a dual citizen of both the United States and the United Kingdom, travel rules have changed as of March 2026. Under the UK's electronic travel authorization system, dual US UK citizens are now required to present a valid British passport or a certificate of entitlement when entering the United Kingdom. Simply traveling on your US passport, even if you are a British citizen, may no longer be sufficient. This is not proposed legislation. This is current operational policy. If you travel to the UK, you need to verify your documentation today. Let me make this real for a moment. Consider a woman I will call Amara. She was born in Nigeria, came to the United States on an F1 student visa 15 years ago, completed her degree, transitioned to an H1B, and eventually naturalized as a U.S. citizen in 2019. Under Nigerian law, she never formally renounced her Nigerian citizenship, and Nigerian law, like many countries, does not automatically revoke citizenship upon naturalization abroad. So technically, on paper, she holds dual citizenship. Amara has never used her Nigerian passport since naturalizing. She is not registered with any foreign government. She has not received any foreign benefits. But right now, because of the Exclusive Citizenship Act proposal, she is terrified. She has called 3 attorneys in the past 2 weeks. She is considering renouncing her Nigerian citizenship, a process that is legally complicated, emotionally painful, and entirely unnecessary under current U.S. law. Here is what Amara needs to hear, and what you may need to hear too. The United States does not currently prohibit dual citizenship for the vast majority of civilians. The State Department has long had a nuanced and non-punitive approach to dual nationality. Nothing in current law, as of this recording, requires Amara to do anything. The fear is understandable. The legal action is premature. The right move is to stay informed, consult with a qualified attorney, and make no irreversible decisions based on a bill that has a 3% chance of passing. So what should you actually do right now? Here is a 5-step action plan that applies to virtually every dual citizen or dual nationality adjacent person watching this. Step 1. Document your current citizenship status clearly. Know exactly which countries recognize you as a citizen, whether that citizenship is active or passive, and what each country's laws say about dual nationality. You cannot make informed decisions without this baseline. Step 2. Monitor the correct sources. Follow the congressional record, uscis.gov, and the State Department's website directly. Do not rely on social media summaries or immigration forums for your legal intelligence. Misinformation in this space is causing real harm. This is what many people are misunderstanding right now, and it could lead to irreversible mistakes. Step 3. Do not take irreversible legal action in response to proposed legislation. Renouncing a citizenship is a permanent act. Doing so in response to a bill that has not passed, and likely will not pass, would be a serious mistake. Wait for enacted law before you act. Step 4. If you work in federal employment, hold a security clearance, or are involved in federal elections, consult an attorney immediately. H.R. 2356 is narrow, but its potential implications for that specific group are direct and serious. Step 5. If you travel to the UK on dual U.S. UK citizenship, verify your passport documentation now. This is not a proposal. This is current policy. Arriving at a UK border with the wrong document is a real and immediate risk. Let me give you the broader picture, because context matters enormously here. For any of these citizenship bills to become law, they must pass both the House and the Senate, survive conference reconciliation if the chambers produce different versions, receive a presidential signature, and, almost certainly, survive immediate legal challenges in the federal courts under the Immigration and Nationality Act and potentially the 14th Amendment. The Exclusive Citizenship Act has not cleared committee. H.R. 2356 has not cleared committee. Neither bill has a Senate companion that I am aware of. The realistic legislative timeline for either of these proposals becoming enforceable law, even in a politically favorable environment, is measured in years, not months. That does not mean we stop watching. It means we do not panic. Executive Order 14160 is a different matter, because executive orders do not require congressional approval, but it is currently enjoined, meaning it is legally blocked, pending the Supreme Court's review. The court's ruling when it comes, will shape the constitutional landscape around citizenship and allegiance in ways that matter. We will cover that ruling in detail the moment it drops. The point is this: the immigration landscape in 2026 is genuinely shifting. The political signals are real. The legislative activity is real. But the actual legal changes that affect your status today remain narrow and specific. Informed patience, combined with genuine legal consultation, is your best posture right now. I want to close with this because I think it is important to say plainly. Your immigration status is not an abstract policy question. It is connected to where your children grow up. It is connected to whether you can visit an aging parent overseas without risking your ability to return. It is connected to your ability to work, to own property, to build a career in this country. It is connected to decades of sacrifice, patience, and legal compliance. That is why I take this work seriously. That is why I am careful with language. That is why I will never tell you something is definite when it is not, or something is safe when it carries real risk. You deserve analysis that respects the weight of what is at stake for you and your family. The 4 developments I covered today: the Exclusive Citizenship Act, H.R. 2356, Executive Order 14160, and the UK ETA change, represent a real and evolving policy environment. None of them require panic. All of them require attention. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. Drop your visa category or citizenship situation in the comments below. I read every single one, and I use your questions to shape future coverage. If this video helped you understand something that was confusing or frightening, share it with someone in your community who needs it. And if you believe in factual, responsible immigration coverage, hitting that like button tells the algorithm that this kind of content deserves to be seen. I will see you in the next one.